Welcome back. We're still looking at the Election Petition Tribunal rulings. The legal implications, the travesty of justice. Would they be good for our jurisprudence? Is the decision of the tribunal legally tenable? These are some of the questions we're hoping we'll get answers to. And I have in the studio Lateef Ali and Upai Ukairo, a legal practitioner. So, but he asked the first question. Maybe you have a question you want to ask him.
Well, the question is very clear in my mind. What other modalities could we fashion to determine disputes after elections? Because I can't imagine. Maybe you can throw some light on it.
The only way we fashion disputes after elections is by going to the tribunal. If you're not satisfied, you go to the Court of Appeal. If you're not still satisfied, you go to the Supreme Court.
Yes, if that is so, can we then, because there have been wrong decisions which leading to travesty of justice, throw away the baby with the bathwater?
Now, in most cases...
Because my take, the way you're flowing is that because these decisions have been irksome in several quarters, that they shouldn't really be allowed to stay.
Don't forget one thing. Opinions of judges are not unique. What the judge, let me use a football field, for instance. No matter what the referee blows during the course of the match, would not stop the match from going on. The referee's opinion the referee opinion stands. It stands still. Then you can appeal against it, and that's what is happening. I'll give you an instance. Part of the instance, I'll take you back to Abia. You said...
It's like you like Abia too much.
No, I studied Abia's ruling. It's not that I'm not from Abia, but I studied Abia's ruling. And one of the hula baloos in Abia's ruling was that judges nullified three local governments. Am I correct?
Yes, sure.
Good. And to Abians, to some Abians, they believe there should be a rerun. But let me get you straight. Are you here with your Electoral Act?
Yes.
Go to section 50 of your Electoral Act and help me read it out.
50, maybe you got it. I cannot.
Okay.
Because,
okay.
We're trying to find our Electoral Act here, so just give us a few moments to find our Electoral Act.
At it, presenter, let me say this, that election petitions, they are not rocket science. It's an issue of mathematical calculations of who scored the highest votes as recorded in forms. Now, if you go by that,
okay,
the duty, okay.
Now, sorry, I heard here. It's 52, section 50, section 53, sub 2 of the Electoral Act, and I read. It says, where the votes cast at an election in any polling unit exceed the number of registered voters in that polling unit, the result of the election for that polling unit shall be declared void by the commission, and another election may be conducted. Underline this word, may be conducted at a date to be fixed by the commission where the result at that polling unit may affect the overall result in the constituency. Now listen, underline that we are lawyers. May is not must. May is not shall. It said may be conducted. So the judges use their discretion to say, instead of declaring a rerun for those three constituencies, they pulled together the votes and declared OT and declared INEC to give OT the return certificate.
Surely, excuse me, with due respect, let me comment quickly so that we don't mislead our viewers. The law is very clear that once those people who are supposed to have voted and whose votes are supposed to count, that if the number is more than the difference in the votes of the so-called winner and the loser, then there has to be a rerun. In that of Abia...
No, let me cut you short. Sorry.
Please,
it's not, they didn't say there must have, it didn't say must. Underline the word may. Use the word may.
There are two mays there.
May, not must.
Where the result at that polling unit may affect the overall result in the constituency.
May, good, that's what I want to use.
May affect, said where the result at the polling unit is this. That's why I said this is not rocket science. It's 1 + 1. In that of Abia, the 3 local governments, the total number of votes which have now been nullified is 200 and something thousand. Meanwhile, the paltry difference between the incumbent governor and the opponent is 50-something thousand. So you now disenfranchise 230-something thousand people in order to declare somebody a winner who is only leading by 50,000.
But this has a literal interpretation. This has a literal interpretation.
May and shall in several decisions have been interpreted.
No, they cannot be synonymous.
No,
may and shall cannot be synonymous. No, I beg to differ.
In a situation
I beg to differ. No,
in a situation where if you don't do that, you deprive somebody of a right, that may is interpreted as shall. Where in a situation where the law says a person or an authority or a body may do something, yes, it doesn't carry compulsion. But we are not doing that. We'll deprive somebody of a right vested. That may is interpreted as shall.
I don't know. At least I have a little knowledge of grammar, and I do know is the constitution written in any other language but basic English?
Yeah, this is basic English. That's what I'm trying to tell him. This has a literal interpretation. It is not
the guiding phrase. The guiding phrase.
This does not require a mischief. This does not require a mischief or a golden interpretation.
Okay, I am not a lawyer, but let me ask a question here.
Yeah.
You said there are 200,000 votes. Since you guys have chosen to dwell on Abia,
yeah.
Since there are 200,000 votes, between the two of them is 50,000 or thereabouts.
Yes.
Okay. Of that 200,000 registered voters,
yes.
That's what you had there, right?
Yes, about it.
Was it the 200,000 registered voters that were accredited?
No.
No.
No,
okay.
Certainly no.
Okay, so what's the guarantee that of the 200,000 voters, if a rerun is done, the 200,000 registered voters will come out?
The question is simple. You give a person a right, and the person exercises it in a manner he or she chooses.
Okay.
You do not, because you cannot determine how that right will be exercised or in whose favor, in whatever way, you deny that person the right. That is a citizen's right. To right to vote.
Okay, that's about registration. Yeah. So let's come back to the point where you guys were arguing about the may or the shall. He says may can be turned into a shall if it affects someone's
that's why I
right.
say I beg to differ. May and shall are not synonymous. No. And this when interpreting the Constitution or the Electoral Act, if they had wanted to use shall, they would have fixed shall. They did not fix may or you use shall in case. It's glaring. And on this premise, the judges base their ruling on. It's so glaring. And there's a locus classicus case that has to do with Modiba against Haruna.
Yeah, in Modiba against Haruna, the decision was very clear. If I may read, there's yet another strong point on which this tribunal goofed, in my respectful opinion. Apart from allegation of non-voting, there are allegations galore in the petition touching on overvoting. On a careful perusal of the record of appeal, one can count 93 of such allegations. Overvoting, put simply, means recording on more votes at a polling unit than those on the list of registered voters. He quoted the section. Stipulates that where overvoting occurs, the second respondent, INEC, shall cancel SEM and order a fresh election.
Hold on. Before you go into the shall and the may again, let me bring in this one. Let's leave Abia and go to Akwa Ibom, for instance, where the tribunal said 18 out of 31 local governments
Yes.
should be cancelled.
Yes.
And then when he goes to the appeal court said everything